And good evening, everybody. I'd like to welcome you to another edition of Cruise Inc. Radio 102.8 live TV streaming. Hope that you had a great Thursday. It is now 8:02 p.m. here in Cap City, and we are again glad to be with you in this live broadcast. We're going to be bringing you some great information tonight, and we have somebody with us that's going to be able to provide some resources on the topic moratorium on evictions and the Commonwealth. I'd like to say that we're only going to air this broadcast on two of our Facebook channels, but because of the topic tonight, I decided to also share this on my personal page as well as our Cruising Radio Facebook page, our Richmond VA Things to Do group page. I'd like to welcome all the viewers there and also on our Cruising Radio 102.8 TV YouTube page. Thank you to our sponsors that allow us to continue to broadcast each and every week. Ms. Pamela Jones, thank you, one of our gold sponsors. Also, Dr. Jonathan Shepard, who is a client and a gold sponsor as well. Colson Enterprises, Gerald's Bail Bonding, and Brian McGaney Enterprises, Ariva Trammell, and also Terry Sherman. Thank you all for your sponsorship, your donations, and more than anything, thank you for your support. I want to let you know if you have any questions that you can put the questions inside of the comments, and we will be looking at those questions and asking our guests to answer them if possible. Again, we are honored tonight to have with us Ms. Janae Craddock, who is the staff attorney for Central Virginia Legal Aid Society. Welcome, Janae. How are you doing this evening?
Good evening. Thanks for having me.
Great.
Thank you.
Fantastic. Before we get into our subject tonight, tell us a little bit about you and how you got into law and all that wonderful stuff.
Oh, wow. Before I begin, just let me know if any time if you can't hear me. I know we're all doing this virtual thing here, so it's unprecedented times. But once again, my name is Janae Craddock. I'm actually a native of Richmond, Virginia, born and raised here. I attended the Richmond Public School System, a graduate of Richmond Community High School. I went to undergrad at the University of Virginia, where I earned a bachelor's in government with a minor in history, American history. I went to law school at Campbell University, a small private law school located now in Raleigh, North Carolina. I graduated in 2007 and returned to Virginia to study for the bar. I took the bar in October 2007 and in July of 2007 and was sworn in October of 2007. And it's all she wrote since then. So my first job was in 2008 with the City of Richmond Commonwealth Attorney's Office. And I was in that position from 2008 until 2019. So in that position, I was an assistant prosecutor, Commonwealth attorney, as we call him here in Virginia, primarily assigned to the Richmond Juvenile and Domestic Relations Court. So I did a lot of cases involving domestic violence, sexual assault, things of that nature. I am now with the Central Virginia Legal Aid Society, where I am the housing law attorney. I have an office on the second floor of the John Marshall Courts building, and I specialize in housing, in particular eviction, landlord-tenant law.
Awesome. And we'll give a big shout out to somebody that you and I know, and that's Miss Colette McKeithen.
Yes, I know her very well. I've known her since the beginning of my career. She is one of my former bosses, so she is a great woman.
Yes, she said great things about you as well, and no pressure tonight, so that you're going to represent her well.
No pressure, right?
No pressure whatsoever. So thanks again, Colette, for actually helping us to prepare for this tonight. We want to talk about our topic is a moratorium on evictions. And this is both, Janae, a sensitive and serious subject. Sensitive because, one, it's humiliating and also embarrassing. If anybody has ever lost any income due to medical reasons, divorce, or being laid off, and what I coin is no fault evictions. That's very sensitive, and also it's serious because it can be mentally and emotionally impactful as well. But I want to talk about before COVID, and I'm going to show something on the screen here because before COVID, Richmond, in particular, and all the cities in Virginia were some of the highest, probably in the country. Let's take a look at this. Now, I don't know if everybody can see that, but Virginia cities with the highest evict has the highest eviction rates in the United States. And as you can see, for large cities, Richmond is number two. Hampton Roads was number three, and my eyes. Okay, I'm not Superman. So anyway, of the cities in the United States, we have five that's in the top 10. And then when it comes to mid sized city, we have Petersburg, Hopewell, and Portsmouth that are, again, among the highest in the country. In your opinion, what is going on in Central Virginia that pre-COVID that we had so many evictions?
So if I can actually go back, what I failed to mention is that my position was actually created in response to the eviction crisis. This came to everyone's attention. Matthew Desmond wrote a book called entitled Evicted, which brought the attention to Richmond. There was a New York Times article written in April of 2018 that brought attention to the crisis, so to speak, that's going on in Richmond. As a result of that, Central Virginia Legal Aid Society obtained some funding to start my position. The idea was that there would be, if we could have someone housed in the courthouse, it would provide one, just convenience for those that are going through the process, but also there's a lot of people who do not even know that our organization exists and there are services that they may qualify for to help them out during this crucial time period. So the idea was to make us more visible and to have us in the courthouse as a convenience to try to tackle the problem, to kind of get ahead of the problem. So I don't know exactly, just to be quite honest, why Richmond is number two rather in the nation, but there are several factors. Richmond is an urban environment with with some very impoverished communities. Second of all, the filing rates who file an unlawful detainer in Virginia was only $58 pre-July 1. I believe it's now $63. And so in other states, the fee for landlords to file unlawful detainers is significantly higher. And so there's less money going out to actually file the paper. So $58, if you're actually in a commercial business, that's really not, that's not that much money in the grand scheme of things. So it's easy for landlords to file unlawful detainers in Virginia, as well as, I think if you just look at the demographics, you look at the poverty rate here, it kind of goes hand in hand.
Now, one of the things that, again, you mentioned the unlawful detainer warrant, and then you have the warrant in debt, and then you have the pay and quit. Can you break those down in terms of what they are for our viewers?
Sure. So let's start with the 5-day pay or quit. The 5-day pay or quit is something that's actually required by the VRLTA, which is the Virginia Residential Landlord Tenant Act, which is a part of the Virginia Code. And landlords if someone is late on their rent. So if your rent is due on the 1st, and some people have a grace period, some people don't. But once your rent is late, the landlord is required to send you a notice notifying you that you are late, notifying you of the amount that is owed, and giving you that 5 days to pay it, essentially. And that's to notify you that if you don't pay within that time period, you either can leave the residence or they will initiate eviction proceedings to have you removed from the residence. So that's the 5-day pay or quit. It's the legal notice that's required before any type of unlawful detainer can be filed in the Virginia courts. And that serves as notice. It puts that tenant on notice that they in fact owe that amount and the consequences of not paying it. Okay.
I am a court uh, TV show junkie here. Of course, I watch People's Court and all those, and a lot of times people come to court with their landlord, and they're trying to counter to the landlord because of certain things that were not taken care of, and a lot of people withhold their rent. Is that something that can be done, and where you have a recourse in that proceeding?
So I always tell people the quickest way or the fastest way to be evicted in Virginia is to not pay your rent and withhold your rent, regardless of the situation. Virginia is not one of those states where you can withhold rent because you are unhappy with your landlord's or lack of maintenance, lack of care, things of that nature. The remedies that we have in Virginia is one, a tenant's assertion. A tenant's assertion is the vehicle or the tool that's used to put your money into escrow, your rent money into escrow, and notifying your landlord that, hey, we've got some issues in this property. I've provided written notice, because you have to provide written notice of the issues to your landlord. You have to give them a reasonable amount of time to comply with or fix the issue. And if they do not respond, you are allowed to file the tenant's assertion within your local civil court, pay that money into escrow, and then the court can set a trial from there so you can argue your case. And the judge will determine whether the landlord is due and owe that money, or if it's something that can be returned to you. Also can order the landlord to make the repairs. Another remedy is the lease can be terminated without those penalties. So, and also in July 1, a new law went into effect. It's the repair and deduct law. So,
Right.
say for instance, you've been asking your landlord for repairs, they haven't made those repairs. You took it upon yourself to make those repairs, and you can deduct up to $1,500. Cannot deduct more rather than $1,500 or 1 month's rent, whichever is higher, if there is an issue that's raised. So that's a defense. So if you tell your landlord, well, I'm not going to pay you but $200 this month, and my rent is $900, and this is the reason why, your landlord may still actually file an unlawful detainer on you, because you still have to give them the proper notice that these repairs need to be done. And then you can assert that defense at court if you are brought to court.
Do you have documentation? Because you just can't say, "Oh, I made this repair," or some people think that they're jacks of all trades. They say, "Yeah, well, I went on and patched up the roof or what have you." Does it have to be documentation showing that you brought supplies, or that you some type of video to offer into evidence?
So good question. It actually is to be done by like a licensed contractor, a licensed pesticide individual, so that there is some type of documentation and proof of the repair that was made.
This thing here again, and what we have been talking about is, a lot of things pre-COVID, and since the pandemic, a lot of things have changed. In fact, we see more signs like this right here: eviction plus COVID equals murder, and that this is a widespread problem, and it's not just relegated here to the Commonwealth. Do we? I mean, we have to look at, I guess, also from the landlord's perspective, because I saw a post the other day said landlords need to get a real job. My question, when it comes to this moratorium, are landlords protected, say, from their banks, or perhaps the person that they're having to pay for the property?
So I know that several mortgage companies offered, 3-month grace periods or forbearance when this pandemic first, I guess we were first stricken by the pandemic. But I'm not certain as to what individual banks or anything may be doing as far as mortgage. What I can tell you is that Virginia was the recipient of $50 million in CARES Act funding, and it was distributed through to each jurisdiction. In the Richmond area, that money is being administered by an organization, the acronym is ACTS, Area Congregations Together in Service. Mm-hmm. And that's not just the rent relief program, that's also the rent and mortgage relief program. So individuals who are behind on their mortgage can also apply for those funds as well.
Also, do you have to show some type of documentation that you were actually impacted due to perhaps your job closing or, again, significant loss of income? Is that also a requirement in terms of applying and perhaps receiving those funds?
It's not the type of funding where you have to show that you had a loss of income due to COVID-19, unlike House Bill 340 in Virginia, which allows for 60-day continuous, where you have to show that you have had some type of impact from COVID-19. This is strictly a rent and mortgage relief fund to assist those who are, the idea person in that situation would be someone who has been current on their rent, and then post, March 18th, April or whatever, when things started to devolve, so to speak, in our country, and a lot of people were furloughed, a lot of people lost their jobs, a lot of people had reduced hours. And so you see this individual who has had a good payment history, and then the bottom essentially fell out during this pandemic. That's the idea tenant, but the reality is that people in Richmond were already struggling pre-COVID, as we've already touched on.
I want to say to our viewers, if you have a question, please place your questions in the comment section. Janae is here basically is to provide information and also resources to help you navigate, perhaps not you, but maybe a loved one or a friend or somebody that you know. They have questions and they don't know necessarily how to obtain certain information, or they're stressed and they don't know what to do. You can go ahead and ask that question, and we'll try our best to, at least they will, to answer the question. I'm just here in the big chair spinning around tonight. So, but even if we don't, we'll try to find the answers for you, because we want to make sure that what we say is, first of all, legal. Second, is factual, and that we're not misleading you in any form at all. So that's our disclaimer right there, is that we want to provide information, want to provide resources to the best of our ability. Now, Janae, there are two different things going on right now. There's a moratorium, if I'm not mistaken, that was in place, and one that was extended. Can you kind of draw a line of demarcation there for us, for the audience?
Sure. So the Supreme Court of Virginia issued a new judicial order stating that it's entitled a moratorium on evictions, but I would say it's more of a suspension on the right to issue writs. And so essentially right now, you can still actually be brought to court for an eviction case. Okay, so that's something that I think some people still think, that evictions aren't happening. They are happening. And they have been happening since June 29th. Actually, they've been happening before then. What the moratorium that went into a place, or should I say when a judicial emergency went into a place back in March, it only applied to residential properties and for unlawful detainers filed for non-payment of rent. So unlawful detainers for breaches, like someone had a non-remediable breach, for example, criminal activity, things of that nature, arrest in the home, they could be, eviction proceedings could proceed against him the entire time. That was never any type of stay on those cases.
Okay.
June 29th is when the Commonwealth of Virginia started the unlawful detainers again, hearing the unlawful detainers for non-payment of rent. And since then, evictions have been happening, and I'll get into all the exceptions in a second. Well, the state that we're in right now is that, as I indicated, there was another judicial emergency order entered by the Virginia Supreme Court stating that effective August 10th to September 7th, that the courts would not be allowed to issue writs of possession. And it's interesting, you got to focus on the fact that it's just issuing writs of possession. So in this process of when you're going through the unlawful detainer process, the unlawful detainer is actually the summons, the paper that comes to your house, the sheriff post on your door, indicating to you that you need to appear on a certain date in court because your landlord is taking you as court to evict you. They want possession of their property. And more than likely, there's also a sum that's attached to that. So they would be seeking a monetary judgment as well. Okay. So you go to court. If the court rules in your landlord's favor, they give them an order of possession, which allows them right to the property. And also they may give like I said, a monetary judgment for the amount that was owed, the filing fee, which I said was $58, which is now $63. Attorney's fees and any late fees. That would be the monetary judgment. Now, even though the court has awarded the landlord an order of possession, it's another step that has to take place. There's actually the landlord filing to have that writ or that order of possession to have a writ executed. Okay. So the writ of eviction is what the landlord would have to file in the clerk's office for. And that gives the sheriff the authority to post that notice on your door saying, hey, we are putting you out on, whatever day, and you need to be out, or we're going to put yourself on the street. Right. So what is not taking place right now is that the sheriffs are not going out. The landlords are not allowed at this time to have those writ of evictions requested. The court aren't issuing those, but that will resume come September 8th.
Wow.
So people are still going through the process. It's delaying with the time that the eviction may occur. Now, while that's not an all-out moratorium, the good thing about that is it allows people more time to either pay and stay. They may be able to come up with the funds that will permit them to pay and remain in the property. But also because there's resources out here. You may be able to get connected with resources, and at the very least, it may give you more time to figure out your next move, as opposed to having a shorter period of time. You may be able to figure out where you're going, some type of respite care, wherever you're going, until that date happens.
Now, two questions here. The word moratorium has been thrown around quite a bit. Define moratorium in terms of.
I don't have my Black's Law Dictionary in front of me, but my moratorium, in my opinion, means that there was something that was in effect, and now there's a stay on it. It's not being done. No one's taking action on it. They're not continuing with that act, so to speak. That doesn't mean that it's outlawed. The perfect example is when there's a moratorium on death penalty in moratoriums, where it's not the death penalty has been overturned or outlawed. It's just that state has decided we're not going to act on that right now, given pending arguments within their legislators or research, right, or whatever the case may be. So that's what a moratorium is when there's a stay in some type of act, some type of proceeding that's still lawful. It's still able to go forward, but the powers that be have chosen not to act upon that authority at the time.
Now you mentioned that you were going to get
You agree
into
with that?
yeah, exactly. I'm on board with that, and because that's my understanding in layman's term as well. It's a almost like a temporary stay until, as you just indicated, all arguments and brief and everything have been filed and everything has been exhausted. In this particular case, I guess when it comes down to the moratorium, quote unquote, it's certain actions are being suspended. I like that word until there's some type of resolution or we come out of this pandemic, whichever one's come first. And who knows when that will be. You mentioned even in this suspension right now, there are certain upsides and downsides. Can you elaborate on that?
I will, but if I could go back, because
Yeah.
there was also, when we talking about the moratorium, there was also the CARES Act, which was the federal moratorium, the Coronavirus Act Relief. Can't remember what the E and the S stand for, but that's the CARES Act is what actually gave us the stimulus money when everybody received that stimulus money that comes out of the same bill and the same legislation rather. And from during the time period that the CARES Act eviction moratorium was in place, which actually ended on July 25th, people who were tenants in houses where the mortgage was federally backed, like a Fannie or Sally Mae mortgage. I'm sorry, not Sally, Fannie or Freddie
Mhm.
mortgage. If there was, some type of low income tax credit property, public housing, if you received any type of federal subsidies like your voucher tenants, they could not be evicted during that time period. Late fees could not be assessed. Landlords were prohibited from actually even sending out notices with late fees and things of that nature
Uh-huh.
out to the individuals. That moratorium went into place on I believe it was the end of May. I'm sorry, March. And it expired on July 25th. Now, there is also a 30-day notice period in that till before the landlords in those covered properties can file an actual, can initiate proceedings. They have to give a 30-day notice to the tenants that of the amount they owe and all that stuff. And then they can initiate the proceeding. So what I think will happen is, so right now you have the CARES Act moratorium, the federal moratorium ended on July 25th. And so the July 26th is when landlords can start that 30-day notice, providing, can start that, giving them the notice. And
Yeah.
so that ends at the end of August, August 26th or whatever. And once that happens, you'll start seeing those new cases coming in. So I imagine that we will see a deluge of unlawful detainers
Wow.
in Richmond, by October, because a lot of our multifamily dwelling properties here were covered by the CARES Act because so many of them had federally backed mortgage, except vouchers, get where I'm going. So,
Sure.
yeah.
So a question came in terms of a private landlord versus, say, Richmond Housing Authority. Are there
Mhm.
different rules, or are they pretty much the same rule applies across the board in terms of the eviction process and the unlawful detainer warrants?
So, like I said, the VRLTA, which stands for Virginia Residential Landlord Tenant Act, is what governs um, the interactions between landlords and tenants. With the federal housing, like public housing, you have the HUD guidelines, which
Uh-huh.
you know they add an extra layer. They have different rules because because of the federal guidelines that they have to comply with. But for most part, the rules are the same as far as providing notice. There may be a different notice time frame as 5 days as opposed to 15 days. Um, the notice. But for the most part, without getting in too many of the particulars, the process is still the same. No one can still be put out until an unlawful detainer is filed.
Makes sense to me. So at what point do you all actually get involved, and do people come to you seeking help? Because I know a lot of times, again, going back to when I was with the Commonwealth Attorney's Office, just had to, that's right, down in Petersburg, we'd be there and waiting on other cases to be heard. And you would see a lot of people that were representing themselves. Do you all at any point represent tenants, or you all basically deal with the law?
I actually represent tenants. We establish attorney-client relationships with tenants. The representation from Central Virginia Legal Aid Society is income-based, kind of like the PD. The PDs represent indigent clients based on their income qualifications. For criminal cases, Central Virginia Legal Aid Society represents individuals who qualify based solely upon their income. So we do represent individuals. We don't just provide information. We go to trial.
So is there a certain income requirement for those that say, hey, I can't afford an attorney, I need some help, and I want to have you all to look at my case? Are there any, again, requirements in terms of your involvement in cases?
So I can give anyone advice. Let me be clear. I can give anyone information, just kind of hand you a flyer. I can, in order to be income eligible, your gross income has to be below 125% below the federal poverty guidelines. And so that's a calculation where you look at someone's gross income. We're able to make deductions for childcare expenses, medical expenses, things of that nature. And if you fall below that 125% of the federal poverty guidelines, you're eligible. When there's a DV case, a domestic violence case, that number is actually 200% of the federal poverty guidelines is what we look at to determine if someone is eligible. And so if someone who is 60 or over, we can give advice to them regardless of their financial qualifications. I may not represent them, say, in court or go to court with them, but I can at least give them advice.
Now, a couple of weeks ago, I think it was maybe in last week, Mayor Stoney talked about some funding to make sure that there is temporary housing for people. Are you guys involved in that at all? Is that just something separate that you have to contact the city?
So to be clear, since my organization, Central Virginia Legal Aid Society, we are not involved in any of the programs that offer resources. We are involved in the advocacy litigation side of things. So we may work hand in hand, but I'm an attorney. And what I do is represent individuals who may have a viable defense to a case in court.
So as we conclude, what and how would people go about perhaps contacting the Central Virginia Legal Aid? And is there certain jurisdictions? I know that you represent the Central Virginia area. Are there also other Virginia Legal Aid societies?
Sure, there are actually there are legal aid societies across the Commonwealth. Central Virginia Legal Aid Society is just the organization that's in the Richmond area. So that's Richmond and Henrico, Chesterfield. They're under Central Virginia Legal Aid also falls our Petersburg office, who represents Petersburg, Hopewell, more of those jurisdictions that are further south of Richmond. And the Charlottesville office actually falls under Central Virginia Legal Aid as well. So if you were to go to our website, centralvirginialegalAid.org or cblas.org, there's contact information for each organization there. Also, if an individual would like to see if they qualify for services, they're also able to go to our website and there is a tab as to how to apply for services. Also, we do have, or should I say, I do have a office on the second floor of the John Marshall Courts building. Either myself or one of my coworkers is there every day, Monday through Friday, typically from about 9 to 11. We only handle the housing cases in that office, though.
And you must have been reading my mind because a question just came in. Somebody wanted to know, in terms of their business, if they're facing an eviction, how would they, of course, go about getting in touch with you, or can they? Is there a difference between business and residential?
Is there a difference between a residential eviction or is that what you're asking?
Well, they were asking if they have a business and they're facing an eviction, would the Virginia Legal Aid Society be able to assist them, well, help them in their legal proceedings?
Typically, we do residential. Quite honestly, a lot of business owners wouldn't even qualify for our services because we usually represent a lot of individuals who are indigent. They don't have many resources. They usually don't have, a significant savings accounts, things of that nature. So, but we typically do, and we do residential. Our focus is on helping the people in the community, the vulnerable individuals in our communities.
Great. And what information would you like to leave with the viewers in terms of some of the things that they may be going through or facing in this pandemic, and especially regarding any eviction proceedings or any
Always
interaction?
to court. Do not miss court. The Richmond has pre-COVID a very high default rate, judgment rate, and I still see it to this day. And when you don't come to court, you take away any defense that you may have. Right now, there are defenses available to individuals, or at least I don't even want to say defenses, but options that were available before pre-COVID. So for example, April 22nd, the General Assembly passed emergency legislation, House Bill 340, which allows anyone whose income has been impacted by COVID-19, they can, if they show proof of, if they're able to show written proof, if they're able to show that they had reduction in income, a letter from their employer, enrichment. In fact, the court is allowing individuals to fill out affidavits, because we understand that a lot of people don't have employers, they're self-employed. You have a lot of people who do Lyft, Instacart, they're hairdressers, and so they do not have an employer that can provide that documentation for them. If you have had sustained and loss of income, or your income has been impacted by COVID, you can ask for a 60-day continuance. And the legislation says that it shall be granted by the court if you're able to show that that you have been negatively impacted. That's major, because it's a 60-day continuance. In that time period, you may be actually working again and be able to make up whatever money you haven't been able to pay. You may be able to connect it to resources that are willing to help you pay your money. But if you don't go to court, what's going to happen is you're going to get a judgment, and the landlord is going to get possession of their property, and that's the end, with no questions asked. So the one thing I can always say, always come to court. Even if your property manager says you do not have to come to court, come to court. Yes,
quite a bit where they change the dates and they tell people, no, don't show up,
Yes.
And now the other thing is that they can accept rent with is it reservation or
Ooh,
president?
that's another topic. Do we have enough time for that today?
I'm gonna have to bring you back because yeah, there's so many nuances when it comes to
Yeah.
this. And also on the next time we want to talk about because some people think you just stay once that default is entered, there is no such thing as an appeal, and we want to talk about that. Is there? Do we have time to mention that?
If there's a default, you can, yeah, you can appeal, but the question is, are you going to have the money to appeal? Because you'll have to come up with the amount of the judgment as well as the filing fee before your appeal can even be perfected.
Wow. Okay. And that's something that I think that's crucial. People need to know is that okay. A lot of times people say, "Well, something happened. I couldn't make the court date," and so again, in your best advice, would you say people you need to contact the I guess not the circuit court, but the general court, and a lot of times is that going to be helpful with contacting them and saying, unfortunately, I have death in my family. I can't make this court date.
I have seen it work when people have contacted the court, and the clerk's office will say that they've received a notice or a phone call from this individual indicating they're in the hospital or, they're sick. Some people have actually sent family members in their absence, like, hey, she is at home, or she just had I was in court yesterday and someone sent a notice because they had just given birth via C-section, so they could not come to court,
Right.
but they notified the court of it, and the court accepted it. So if you can get a doctor's note there for you, that's awesome. I can't guarantee you that it would work, but that's better than nothing,
Right.
or having someone come for you with a notice. I can't say that that's going to work either, but it's worth a shot.
Janae,
Default judgments are bad.
right, exactly. And Jay, hopefully next time that we're together, there will be some type of decision between the Senate and the delegates of the General Assembly. We're not going to get in that tonight because, quite frankly, I don't have enough information to have a logical conversation about what's going on, and also I would like to have either State Senator Joe Morrissey here or Delegate LaShrea Ayers, somebody that's on the front line to help us again to navigate that legal side of things. But we do know we can say this safely that there was no vote or the vote was postponed. Is that correct?
That was my understanding as of this morning. I
Great.
don't know. Yes, that's correct.
Well, thank you again for taking time out of your
Thank
schedule
you.
tonight. The information that you've provided has been just invaluable. And again, tell the people once again where they can reach you, your office number.
Sure. So I'm in the Richmond office at Central Virginia Legal Aid Society. Our main phone number is 804-648-1012. Then we also have a website that is Central Virginia Legal Aid Society.org. It's cvlas.org. And if you go to that website, there's also resources on that website. You can apply for services on that website. So, just go and look and apply.
Well, thank you so much, and I'm looking forward to having you back. And we're going to get into all the other things that we could not cover tonight because there's so much more that we need to talk about, and that residents need to understand because knowledge is power, and that's where I always think. So, thank you so much again for being with us tonight. Anybody want to give a shout out to?
No, I'm just. I hope I lived up to the pressure. That's all.
Well, I will find out. No, seriously, you did an absolutely wonderful job, and thank you again for the information, the resources, and somebody that slipped in a question, or they're gonna have to wait to. Oh, somebody's giving you a compliment. Says thank you, very informative, and let me put that up so that you can see that. Yay! Again, we like to have fun here, but please note that if you all are having some type of issue As Janae said, go to court. Don't miss court. Even if you have to ask for a continuance to get your paperwork together, bring any other documentation, do all those things. And above all, if in doubt, call Janae. Thanks, Janae. You have a great evening.
You as well.
All right, take care. All right, everybody. Thank you again for joining Cruise Inc. Radio 102.8 live TV screen streaming broadcast. We hope that you had a great night and that you find the information valuable here and that the resources. Let us know. Send us an email at cruiseinkradio@gmail.com. If you have any other questions, I'll make sure that I get them to Janae. Again, thank you, everybody. You guys have a wonderful Thursday, and I'll see you again if the Lord say the same on next Thursday. I'll be good to each other. As I always say, whatever reaches the heart, comes from the heart, reaches the heart. Let somebody know how much you love them and how much you care. Have a great evening.